Okay, so we will start a bit late, so we start now. Welcome to the third panel of the 7th Tarragona International Environmental Law Colloquium. And thank you to today's keynote, panelists, organizers, and audience. I hope that the welcome coffee has cheered you up a bit. Um, and and that the time that we spend together, we are spending together, is being enjoyable. Maybe now you also understand why we do the sessions in the afternoon. So yeah, in this third panel, we'll tackle the topic environmental and social energy justice. Some of the questions we pose are: how does energy supply affect the allocation of benefits and burdens between different groups in society? Should energy be a common good? What are the NIMBY effects of the transition to renewable energy? How should they be addressed from a sustainability and justice perspective? So let me remind you briefly the structure of the panel. The keynote speaker will talk 35 minutes, while the panelists will talk 12 minutes each one. Finally, there will be 25 minutes for the discussion session, where all speakers, panelists, and keynote will have the opportunity to debate and answer to the questions of the audience or among the panelists. So we would appreciate if you could keep all to the time. It's Friday, so, and also because some people may leave right after the session, so we will try to be on time. Let me introduce today's keynote speaker, Dr. Anahí Urquiza. She's an associate professor at the University of Chile with an experience in teaching and doing research for over 15 years. She's a social anthropologist and holds a master in anthropology and development from the University of Chile. She has a PhD in sociology from the Ludwig Maximilian Universität München. Anahí teaches methodology, research processes, theory of social systems, and socio-environmental issues. Her field of research focuses on the environment and society relationship, particularly in water vulnerability, poverty, and energy transitions, participation, governance, and resilience when facing climate change. She has wide experience in academic management, the coordination of working teams, as well as the design of methodological analytical frames to discuss complex issues. We're glad about your participation in the colloquium. The title of Anahí's presentation is Environmental and Social Energy Justice. So, Anahí, you are very welcome, and now the floor is yours.
Thank you very much. Okay, thank you very much. But I need to talk in Spanish, but my English is really, really bad, so I'm sorry about that. Y la verdad es que hablaría muy superficial si solo hablara en inglés y no tiene mucho sentido. Entonces, hoy voy a presentarles el trabajo que hemos realizado durante algunos años en Chile y en Latinoamérica, tratando de abordar pobreza energética desde nuestra propia perspectiva, ¿no? Y ahí, a partir de ese abordaje de pobreza energética, hemos avanzado en enfoques más territoriales, considerando las particularidades de los países de ingresos medios, ¿no? Que no es lo mismo que hablar de pobreza energética en Europa o tampoco en países de ingresos muy bajos. Y a partir de eso, los desafíos que involucra enfrentar la pobreza energética y la gobernanza, los esfuerzos por hacer una aproximación jurídica también a la pobreza energética desde la perspectiva latinoamericana. Bueno, lo primero es que cuando estamos hablando de pobreza energética, hoy día es un desafío que es multidimensional, que además tiene que lidiar con los desafíos relacionados con la transición energética, y por lo tanto esta es parte de lo que llamamos la transición justa, ¿no? La transición energética requiere que traslademos el uso de energía, o sea, que las fuentes energéticas pasen a ser fuentes limpias, pero al mismo tiempo nos tenemos que hacer cargo del acceso a la energía de nuestra población, ¿no? De hecho, el acceso a la energía en nuestra población es un requisito para ciertos estándares mínimos de desarrollo y por lo tanto si la población no tiene acceso a ciertos recursos energéticos, en el fondo se reproduce la pobreza y quedan en desventaja en comparación con otra población que sí tiene acceso a recursos energéticos. Además de eso, en el contexto de cambio climático, debemos enfrentar la transición energética porque tenemos que dejar los combustibles fósiles y eso tiene una serie de requerimientos y presiones frente al sistema energético. Pero además de eso, también enfrentamos nuevas amenazas. Por ejemplo, eventos extremos, tormenta, aumentos de temperaturas que ponen una mayor presión al uso de energía en diferentes regiones. O simplemente se interrumpe el consumo eléctrico, o sea, la conectividad eléctrica debido a las condiciones climáticas. Entonces, por ejemplo, en Latinoamérica muchos de nuestros países dependen de la hidroelectricidad y la hidroelectricidad es uno de los ámbitos que se ve más afectado por el cambio climático debido a la escasez hídrica en gran parte del territorio. Entonces, por lo tanto, enfrentamos también un problema de seguridad energética y nosotros lo que hemos visto es que por un lado se trabaja con pobreza energética, por otro lado se trabaja con transición energética y por otro lado se trabaja con seguridad energética. Y desde nuestra perspectiva necesitábamos tener una mirada más integral que además nos permitiese mirar las particularidades de los países de ingresos medios, ¿no? Como es el caso de Chile y muchos de los países latinoamericanos. ¿Qué es lo que nos dimos cuenta al hacer el análisis de cómo se trataba la pobreza energética? Es que en los países con mayores niveles de ingreso, el principal foco estaba en la equidad, ¿no? La equidad en el sentido de cómo los hogares logran, cuánto tienen que destinar para poder financiar sus gastos energéticos y si ese costo es una presión muy grande para el presupuesto de las personas de los hogares. Entonces, por lo tanto, gran parte de la discusión de Europa es cuánto pesa en el presupuesto de los hogares y cómo pueden cubrir sus necesidades energéticas, pero no hay una discusión sobre la calidad de la energía y el acceso a la energía, porque básicamente la mayoría de la población tiene acceso a energía de buena calidad. Por otro lado, en los países de ingresos bajos, la aproximación de pobreza energética ha estado muy enfocada en cuál es el acceso que los países tienen, o sea, que la población tiene a la conectividad, sobre todo eléctrica, ¿no? Y con un gran desafío, haciendo énfasis especialmente en que la población no puede acceder a la electricidad y no puede acceder a fuentes limpias debido a las dificultades de desarrollo y conectividad que tienen los países. Entonces, cuando nosotros mirábamos con estas herramientas la pobreza energética en países como el nuestro, veíamos que en realidad no teníamos problema de pobreza energética. El costo no era tan alto de la energía y la población que no está conectada a la electricidad es muy baja, ¿no? Pero no nos calzaba eso. O sea, claramente teníamos un problema, porque tenemos las ciudades con mayor contaminación de Latinoamérica, por el uso de leña, por ejemplo. Se pasa mucho frío, tenemos muchas enfermedades respiratorias relacionadas y cardiovasculares relacionadas con las bajas temperaturas en el invierno, también con las altas temperaturas en el verano. Entonces claramente habían ciertas dimensiones que no estábamos observando. Y para eso tratamos de abordar y proponer una definición de pobreza energética que fuera más integral y que nos permitiera mirar lo que sucedía en estos países de ingresos medios, ¿no? Entonces para ello lo que hemos trabajado es con una aproximación tridimensional donde miramos tanto el acceso, la equidad y la calidad, ¿no? Cuando el acceso refiere más bien a las condiciones de infraestructura, tecnología que posibilitan o no acceder a ciertas fuentes energéticas. La equidad se enfoca principalmente en el peso que implica o si es que es posible costear la energía para los hogares y si es que el peso es muy alto o si que de frente no lo financian y se quedan sin ese acceso por problemas de acceso a dinero, ¿no? Y en el caso de la calidad nos enfocamos en varios elementos que tienen que ver desde el punto de vista de qué tan adecuado, seguro, confiable es el servicio energético y no contaminante, ¿no? Considerando que el problema que tenemos en muchas regiones con la contaminación intradomiciliaria y extradomiciliaria, ¿no? Y por otra parte, también un elemento clave que consideramos y que tiene que ver con la diversidad cultural latinoamericana y la diversidad climática, es que los estándares para definir cuándo alguien está en pobreza energética o no, no pueden ser establecidos de manera global, sino que tienen que ser definidos con pertinencia territorial, ¿no? En el fondo, son las condiciones del territorio las que nos indican eh, qué tipo de fuentes energéticas se puede acceder, cuáles son los estándares, por ejemplo, de temperatura a los que se pretende llegar, qué tipo de servicios energéticos se requieren. En algunos casos, por ejemplo, el agua caliente sanitaria puede ser crítico y en otros casos no. Entonces, por lo tanto, es una mirada que tiene que ver con cuáles son las características del territorio, cuáles son los estándares, las evaluaciones, los umbrales de tolerancia que tiene el territorio, y a partir de eso, cuáles son esos niveles de calidad que se definen para los servicios energéticos. Entonces, con esto, nosotros lo que hicimos fue tomar la información que existía en nuestro país, partimos por Chile, que existía en nuestro país para estos diferentes servicios energéticos, ¿no? Tanto para cocina e higiene, para iluminación y conectividad para otro tipo de servicios eléctricos, la climatización y el tema de la calidad, de la equidad, por ejemplo, también en el fondo del acceso, el peso que tiene en el presupuesto de los hogares. Entonces tomamos los antecedentes, o sea, los indicadores que estaban disponibles y pudimos empezar a hacer una caracterización más compleja de la pobreza energética, ¿no? Entonces, por ejemplo, podemos visualizar que en nuestro país, en general, no existirían grandes problemas con el uso de fuentes contaminantes para cocinar, ¿no? Sin embargo, sí para calefacción, pero eso no estaba contemplado dentro de los indicadores. También el tema de la ausencia de agua caliente sanitaria es cerca del 10% de la población, pero en algunas regiones puede ser cerca del 25%, lo que obviamente no es menor. 25% de la población sin agua caliente sanitaria cuando tienes bajas temperaturas es realmente un problema. Pero cuando miramos, por ejemplo, el acceso a electricidad, vemos que la población que no tiene conectividad al sistema eléctrico es bajísima, 0,34%, y uno lo mira desde ahí y dice, bueno, en Chile no hay problema con el acceso a electricidad. Pero cuando uno mira la calidad de esa conexión, se da cuenta que cerca del 20% tiene interrupciones permanentes, ¿no? O sea que frecuentemente hay interrupciones de la conexión eléctrica, lo que finalmente genera una serie de dificultades. Por ejemplo, en las regiones que tienen temperaturas muy bajas, una de las cosas que se ha tratado de hacer es que la gente cambie la leña por la electricidad. Pero ¿cómo van a cambiar la leña por la electricidad si la electricidad se les corta frecuentemente? Cuando estás en un lugar con menos 10 grados de temperatura, por ejemplo, no puedes arriesgarte a quedarte sin calefacción. Entonces hay una serie de limitaciones en la calidad del servicio que hacen que sea imposible avanzar hacia combustibles más limpios. Y una de las cuestiones que vimos es que el problema más grave que tenemos es la eficiencia energética de las viviendas. Las viviendas en nuestro país son de muy mala calidad, ¿no? Desde el punto de vista de eficiencia energética, nuestra construcción es de muy buen nivel desde el punto de vista de los terremotos, ¿no? De hecho, somos famosos porque tenemos tremendos terremotos y las casas no se nos caen. Pero frente a la temperatura, las bajas y las altas temperaturas, la verdad es que nuestras casas son como coladores, ¿no? Por lo tanto, eso significa que necesitas mucha energía para poder calefaccionarla. Y cuando hablamos de pobreza energética desde una perspectiva más integral y estamos considerando la necesidad de la transición energética y de reducir el consumo energético en el fondo, la eficiencia energética pasa a ser crucial y es algo que no se había abordado en nuestro país hasta ahora. Por otra parte, también desde el punto de vista de la climatización, podemos ver que a partir de las estadísticas que tenemos, un porcentaje importante de la población declara pasar frío en las viviendas, ¿no? Declara pasar frío en el invierno. Y eso que en nuestro país estamos acostumbrados a pasar frío. De hecho, es muy común que viaja gente de Europa, por ejemplo, a nuestro país y dice que pasa mucho más frío en Chile, en Santiago, en el invierno que lo que pasa acá, a pesar de que las temperaturas son mucho más bajas. Y eso tiene que ver porque no tenemos buena climatización de las viviendas, ya sea por la misma construcción de la vivienda y por las fuentes energéticas. Y por otro lado, cuando vimos el peso que tenía el costo de la energía en el presupuesto, lo desagregamos en dos miradas. Por un lado, los hogares que tenían un peso muy alto, ¿no? O sea que en el fondo, en el presupuesto de los hogares, más del 10% del presupuesto se tenía que ir a financiar energía. Y eso vimos que era cerca del 22%, ¿no? Con los antecedentes que tenemos. Sin embargo, cuando miramos con más detalle los datos que existen, vemos que hay un porcentaje importante de hogares que no gastan una proporción tan alta de su presupuesto en energía, gastan menos del 10%, pero no satisfacen su servicio energético. O sea, en el fondo hay una priorización de servicios, que eso es algo que tampoco se ve en países más desarrollados. O sea, en el fondo es, paso frío o no me baño con agua caliente porque necesito comer, ¿no? Entonces, esa realidad estaba siendo invisible con las otras conceptualizaciones. Bueno, este análisis nosotros ya lo hemos hecho en varios países de Latinoamérica, que nos permite tener una aproximación más completa sobre estas diferentes dimensiones, pero sin embargo, una de las cuestiones que hemos encontrado es que lo más crítico es que no tenemos acceso a buena información. O sea, si en Chile teníamos problemas de información, en el resto de los países de Latinoamérica es aún peor, ¿no? Entonces, por lo tanto, estamos un poco ciegos frente a lo que sucede. Al mismo tiempo, nos dimos cuenta de que hay una cuestión territorial que es fundamental en el análisis de la pobreza energética. ¿A qué nos referimos con esto? A que la mirada desde la pobreza energética en el hogar puede ser muy productiva para entender cuáles son las condiciones que el hogar tiene para entregar los servicios energéticos. Sin embargo, cuando estamos considerando las condiciones del territorio, nos damos cuenta que gran parte de esas dificultades no tienen que ver con el hogar, sino que tienen que ver con el territorio. ¿A qué nos referimos con eso? Territorios donde efectivamente no llega el acceso a ciertas fuentes energéticas, ¿no? Por las condiciones geográficas, por las condiciones económicas, por las condiciones políticas, por diferentes condiciones. Al mismo tiempo, territorios donde por el clima los requerimientos energéticos pueden ser muy altos en un momento u otro, o por el acceso a herramientas para construcción, ¿no? Materiales de construcción, tampoco es posible construir o desarrollar viviendas de mejor calidad. Entonces hay una serie de elementos que en realidad no tienen tanto que ver con el hogar, sino que tienen que ver con el territorio, ¿no? Y para qué decir en Chile y en el resto de Latinoamérica, ¿no? Problemas que tienen que ver con los espacios públicos, o sea, cómo los espacios tienen la iluminación necesaria, las escuelas o los servicios de salud tienen las condiciones climáticas que se requieren para poder resguardar la salud de la población. Son todas dimensiones que no podemos ver cuando estamos mirando solo desde pobreza energética. Entonces, por lo tanto, nos propusimos desarrollar un análisis, una conceptualización que nos permitiera mirar también qué es lo que pasa con el territorio y en el contexto de transición energética y seguridad energética, ¿no? O sea, mirar el territorio, porque también la pobreza energética es algo más estático, ¿no? Es hoy día. ¿Cuáles son las condiciones que hoy día tiene el hogar? El problema es que en un contexto de clima cambiante, donde cambian los requerimientos energéticos, necesitamos más energía para, por ejemplo, regular la temperatura, o tenemos más dificultades para poder cubrir los servicios energéticos por los cambios en la pluviometría, ¿no? Hay menos disponibilidad para la hidroelectricidad. Necesitamos mirar también cómo se proyecta las fuentes energéticas y la provisión de servicios energéticos considerando esas condiciones territoriales. Y la transición energética, por supuesto, que además implica dejar ciertas fuentes de energía para poder avanzar en la carbono neutralidad. Entonces, para ello, nosotros lo que hemos hecho es una aproximación que permite mirar la vulnerabilidad energética de los territorios, considerando las necesidades energéticas y los servicios energéticos disponibles a partir de las condiciones del territorio, las condiciones actuales y proyectadas, donde hay una espacialización de la pobreza energética que nos permite entenderla y problematizarla de una forma que genera condiciones para ser abordadas desde la política pública, ¿no? O sea, desde la política pública no puede ir solamente el esfuerzo en hacernos cargo de los hogares o entregar subvenciones, sino que cómo transformamos el territorio para que efectivamente los requerimientos energéticos sean menos, los servicios energéticos estén disponibles y efectivamente los hogares puedan acceder a los servicios energéticos que requieren. Entonces, ahí una de las cosas que hemos visto es que para poder hablar de seguridad energética necesitamos considerar tanto la sustentabilidad y la resiliencia de los servicios energéticos como la pobreza energética y el acceso equitativo a la energía, que son dos cuestiones que hasta hoy día generalmente van por separado. Hay ciertas escuelas que se concentran en pobreza energética y otras que se concentran en la transición energética o la seguridad energética. Y la verdad es que no podemos concentrarlo solo en uno, sobre todo en países como los nuestros, donde no tenemos el otro lado resuelto. También es normal que esto tenga menos relevancia en países donde la pobreza energética no es tan relevante como países como los nuestros, pero en nuestro caso no podemos pensar en transición energética si tenemos una población que no puede acceder a los servicios energéticos. Entonces la necesidad de abordar esto de manera integrada nos ha hecho mirar a nivel latinoamericano cuáles son los principales desafíos que hay en contexto de cambio climático para los servicios energéticos, ¿no? Entonces, por ejemplo, esta imagen es de México y Centroamérica, ¿no? Donde vemos cómo hay ciertos problemas que ya están diagnosticados, como los blackouts eléctricos, las malas condiciones de los hogares, de las viviendas, las olas de calor que ya están proyectadas a partir de la información que existe, los altos precios que hay en comparación en ciertos territorios, en ciertos países de Latinoamérica, el exceso del gasto energético por las diferentes condiciones que tienen de eficiencia energética en los hogares y en las instituciones. Bueno, y a partir de eso nosotros empezamos a identificar cuáles son estos principales nudos críticos que nos permiten mirar las condiciones de inseguridad energética para nuestros países. Y lo hicimos también para el Caribe, ¿no? O por supuesto que una de las cosas que queda muy en evidencia, que uno de los grandes desafíos que tenemos es que no hay información. En muchos países no hay información, prácticamente. Y en otros la información que tenemos es bastante incompleta. Y en Latinoamérica también hicimos lo mismo, ¿no? Donde tenemos esa descripción que nos permite mirar estas diferentes amenazas, tanto territoriales como desde el punto de vista de la calidad de la energía a la cual pueden acceder la población. Entonces, a partir de esto, hemos trabajado con el concepto de vulnerabilidad energética territorial, donde lo que hacemos es concentrarnos en la mirada de cómo el territorio tiene o no tiene la posibilidad de asegurar un acceso equitativo a energía de calidad de forma resiliente para los servicios que se requieren en ese territorio, ¿no? Y ahí considerando tanto los riesgos socionaturales, ¿no? Todo lo que tiene que ver con la proyección que tenemos de cambio climático y las necesidades de transformación, como las brechas en el acceso por pobreza energética, ¿no? Que era lo que ya habíamos identificado antes. Ahora, no es nada fácil esto cuando empezamos a decir que tiene que tener pertinencia territorial. Uno se pregunta, bueno, ¿cómo entendemos el territorio, ¿no? Y el territorio, para poder abordarlo, lo definimos considerando los servicios ecosistémicos, los servicios socioculturales, que tienen que ver, por ejemplo, con todas las reglamentaciones y cómo se estructura la sociedad desde el punto de vista cultural, social, jurídico, para poder definir qué es lo que sucede en un territorio en particular, y los servicios sociotécnicos. Y es en los servicios sociotécnicos donde están principalmente las condiciones energéticas, ¿no? Que tienen que ver con los diferentes servicios sociotécnicos, pero acá ponemos énfasis en el sistema de la energía, donde están ciertas características ambientales, ciertas características de infraestructura, de tecnología, de normativa, una serie de elementos que están en torno al servicio sociotécnico que van definiendo cómo se puede ver afectado o no por las condiciones que se proyectan. Entonces, nuestro análisis sobre los servicios energéticos lo hacemos concentrándonos en los sistemas sociotécnicos, mirando cuáles son las regulaciones, las políticas que están orientadas a partir del sector público, cuál es la distribución y la generación de energía que está en nuestro país, por ejemplo, principalmente en el sector privado, eso obviamente depende de los distintos países, y cuáles son las características de los consumidores, ¿no? Sin embargo, al mismo tiempo tenemos que considerar que en los territorios, desde el punto de vista sociocultural, hay ciertas regulaciones políticas, jurídicas, condiciones científicas de la información existente, económicas de cuál es el movimiento económico que hay en ese territorio, cuáles son las condiciones de acceso a la energía, a los distintos modos de vida y cómo hay la relevancia que tiene la energía para poder mantener esos modos de vida, etc. Y además el sistema ecológico que define en el fondo cuáles son las condiciones climáticas, geográficas, etc. Entonces con esto nosotros lo que hacemos es mirar a partir de la misma conceptualización del IPCC, que refiere a cómo entendemos el riesgo, ¿no? Alineándonos con los esfuerzos del IPCC, miramos la vulnerabilidad ahora del sistema sociotécnico, ¿no? Y desde esa perspectiva nos permite hacer un análisis mucho más completo para poder visualizar cómo las amenazas que están relacionadas con los distintos territorios pueden tener impacto en diferentes ámbitos del servicio sociotécnico, ¿no? Que tienen que ver con la disponibilidad, con la confiabilidad, con la demanda, porque también, por ejemplo, con las olas de calor aumenta la demanda de la energía, con los precios. En los países cuando está en manos privadas, por ejemplo, hay menos disponibilidad de energía por la crisis hídrica y eso implica un aumento de precios. Entonces miramos cómo esos impactos intermedios terminan afectando el acceso a los servicios energéticos, tanto para el punto de vista de los servicios que requieren los hogares, ¿no? Desde el punto de vista de la climatización, la higiene, etcétera, como también desde el punto de vista productivo. O sea, es una mirada mucho más completa. Y para ello, obviamente, también necesitamos una serie de elementos que nos permitan mirar cuáles son las condiciones de vulnerabilidad de los sistemas, y para eso no solamente vemos las amenazas, sino que cómo los sistemas son capaces de enfrentar esas condiciones de amenaza y irse recuperando, adaptando frente a las características del territorio. Para ello tenemos una mirada bastante detallada sobre cada una de estas dimensiones de sensibilidad, que la verdad no vamos a profundizar ahora porque no tiene sentido, pero sí quiero como que se dimensione la gran variedad de información que se requiere para entender cuando estamos hablando de vulnerabilidad energética territorial, ¿no? O sea, que tiene que ver desde cuáles son las condiciones del mercado en energía, pasando por las condiciones sociodemográficas y los requerimientos energéticos. La población, por ejemplo, la concentración de población mayor hace que sea mucho más exigente las condiciones de climatización frente a olas de calor. Las condiciones de infraestructura y tecnología, qué tan robusta es la infraestructura, por ejemplo, frente también al aumento de temperatura. Sabemos que la conectividad eléctrica se ve afectada, o frente a ciertos eventos extremos, si es muy frágil, puedes dejar sectores del país desconectados de la electricidad fácilmente. Y también cuáles son estas dimensiones de conocimiento y cultura, y más bien características más culturales de la población, que hacen que muchas veces tengamos recursos para poder enfrentar ciertas dificultades, y en otros también grandes que en el fondo profundizan las dificultades para ello. Una de las cuestiones fundamentales que hemos visto es que para enfrentar una gran diversidad de amenazas, el concepto de resiliencia de los sistemas sociotécnicos pasa a ser clave. ¿Por qué resiliencia? Porque en el fondo, como tenemos diversas amenazas, la resiliencia nos permite mirar cómo los sistemas son capaces de enfrentar esa diversidad de amenazas e irse transformando a sí mismos para poder mantener la provisión de ciertos servicios energéticos, ¿no? Y en ese sentido, cuando hablamos de política pública y cuando hablamos de los esfuerzos que tenemos que hacer para poder proteger los servicios energéticos y entregar esos servicios energéticos a la población, mirar cuál es la diversidad que hay, por ejemplo, en las fuentes energéticas, cuáles son la calidad de la conectividad, cuál es la capacidad que tenemos para conocer, para generar información sobre nuestros propios servicios y requerimientos energéticos, y al mismo tiempo, qué capacidad tenemos para transformar las condiciones de generación de estos servicios, de acceso, y cuál es la capacidad que tenemos de tomar decisiones frente a ello, es crucial. A veces uno puede decir, bueno, esto parece evidente, ¿no? O sea, obvio que tenemos que tener la capacidad de decidir, pero en países como los nuestros no es tan fácil eso. Por ejemplo, en Chile está en manos del mercado. sea, y por lo tanto, aunque tomemos la decisión política de de avanzar, por ejemplo, en la transición energética y ponerle fin a la producción de energía a través del carbón, la verdad es que por mucho que tengamos esa visión política no lo podemos hacer porque es el mercado el que lo regula y jurídicamente está establecido así. Entonces las transformaciones que hay que hacer también pasan por la capacidad que tenemos para generar esas transformaciones. O sea, cuál es la capacidad que tenemos para tomar decisiones sobre el territorio y sobre cómo enfrentamos los desafíos. Y eso, por supuesto, que son miradas mucho más difíciles de identificar. Ahora, estos elementos creemos que no podemos dejarlos de lado cuando estamos hablando de una transición justa, ¿no? Muchas veces cuando se habla de transición justa se reduce la observación a, por ejemplo, la reconversión laboral de cuando se cierran las plantas de carbón. Pero eso desde nuestra perspectiva, es una mirada demasiado acotada que en países como el nuestro no tiene sentido, porque finalmente eso es un desafío que tenemos que enfrentar con un grupo de población muy definida, pero hay otra dimensión que es mucho más amplia, que afecta a casi toda la población, que tiene que ver cómo transitamos al uso de energías renovables, sacamos el carbón de nuestra matriz y al mismo tiempo nos hacemos cargo de las necesidades energéticas de nuestra población. Y eso considerando, por supuesto, las condiciones del territorio. Entonces, esta aproximación, lo que tratamos de hacer es una mirada mucho más integral que nos permita hacernos cargo de ese desafío más complejo y considerar estas diferentes dimensiones de la transición justa. Entonces, cuando hablamos de justicia energética, ¿no? Parte del desafío de hablar de justicia energética es ser capaces de observar estas diferentes dimensiones, que en muchos casos, en países como los nuestros, son dimensiones que son absolutamente invisibles porque no existe información, pero también por una cosa bien particular que tiene que ver con el propio colonialismo académico, ¿no? Y es que en el fondo miramos nuestros países con lentes que fueron desarrollados para otras condiciones. Entonces, cuando miramos nuestros países con los lentes que se fueron desarrollados para mirar las condiciones europeas, por ejemplo, queda gran parte de los desafíos que tenemos que enfrentar fuera. Entonces, hablar de justicia energética también requiere que seamos capaces de construir nuestras propias herramientas conceptuales que nos permitan mirar esta complejidad, ¿no?, en territorial. Y aquí enfrentamos, cuando estamos considerando esto, obviamente hay un tremendo desafío en la gobernanza de la pobreza energética, uno podría decir, ¿no? O sea, efectivamente el foco final está en el hogar, ¿no? En el hogar y cómo afecta a las personas. Por eso que pobreza energética es tan potente, ¿no? Porque nos permite mirar cómo las personas pueden o no acceder a esos servicios energéticos. Pero el tema y el esfuerzo que nosotros hacemos es decir, de acuerdo, tenemos que mirar eso. Pero para entender lo que pasa ahí, para resolver los problemas y hacernos cargo de que exista la disponibilidad de energía y las posibilidades de acceder a los servicios energéticos, necesitamos mirar el territorio. Entonces, por lo tanto, nos tenemos que preguntar que cuando hablamos de energía, cuál es el objeto de las políticas públicas. Ese objeto de políticas públicas va desde el hogar hasta las condiciones del territorio, de la infraestructura, las configuraciones del mercado, los diferentes ámbitos que nos permiten definir la disponibilidad de los servicios energéticos de manera equitativa. Pero además de eso, necesitamos hacerlo considerando las perspectivas del territorio, ¿no? O sea, no podemos imponer una misma visión sobre qué es lo que se requiere para los servicios energéticos o cómo se regula cuando hay condiciones territoriales que son distintas. Condiciones territoriales culturales, climáticas y geográficas también, en muchos casos, por ejemplo, las islas o las zonas que están aisladas en Latinoamérica son muy importantes y que no es llegar y plantear ciertos servicios energéticos donde no es posible llegar. Y por otra parte, necesitamos, en el contexto de la sociedad contemporánea, obviamente esto no es solamente para Latinoamérica, ¿no? En el contexto de la sociedad contemporánea nos enfrentamos a esta diferenciación funcional donde la lógica económica opera con sus propias racionalidades, la científica con la propia racionalidad, la política con su propia racionalidad, y no es tan fácil coordinar esas racionalidades para poder generar esfuerzos que nos permitan abordar estos temas. Entonces, ¿cómo logramos tomar decisiones que permitan incorporar las condiciones del mercado, las condiciones del territorio desde el punto de vista cultural, las condiciones jurídicas que existen ya en los diferentes países y a partir de ello generar desde una perspectiva legítima un abordaje que sea mucho más integral? Sin duda, mirado desde ahí, los esfuerzos de gobernanza en pobreza energética van mucho más allá de generar subsidios para que en el hogar puedan cubrir la cuenta de final de mes, ¿no? Es una mirada bastante más compleja. Bueno, y para cerrar, algunos elementos que me parece que son clave dejar sobre la mesa, ¿no? Es la necesidad de pasar por sobre esta polarización entre equidad y acceso, ¿no? O sea, no podemos hablar, no hay una opción entre hablar de pobreza energética solo desde la equidad o solo desde el acceso, sino que necesitamos una mirada más integral donde la calidad aparece como un fenómeno muy relevante, la calidad de las fuentes energéticas, la calidad de los servicios energéticos, la calidad de las viviendas, pero también considerando que a través de la calidad podemos definir cuáles son esos umbrales de tolerancia, ¿no? Umbrales de tolerancia en cuáles son los servicios que se requieren, cuáles son las fuentes energéticas que son aceptadas o no son aceptadas localmente para poder definir políticas que sean pertinentes desde esa perspectiva. Nosotros ya tenemos a esta altura una revisión bastante completa con los datos existentes en Latinoamérica sobre pobreza energética, considerando esta visión más integral y más compleja. Al menos desde la definición tridimensional de pobreza energética, recién estamos empezando a hacer una caracterización más completa desde el punto de vista de vulnerabilidad energética territorial, porque como ustedes ven, contempla mucho más información que tiene que ver con los territorios, con los ecosistemas, con la dimensión jurídica, con las instituciones que operan en los diferentes territorios, entonces es bastante más complejo, pero también hemos avanzado en eso. Sin embargo, la información, la data disponible es tan limitada en Chile y en otros países de Latinoamérica que ahí tenemos un grave problema, ¿no? Un grave problema de que sigue siendo invisible y seguimos sin herramientas para poder contribuir a caracterizar el fenómeno que permita generar políticas públicas de acuerdo, porque la data existente es de muy mala calidad. ¿Mm? Ahora, finalmente, para cerrar, ¿no? Dos cosas que me parece que son clave. Una es la necesidad de visibilizar las características territoriales cuando hablamos de estos fenómenos, y que cuando miramos, sobre todo cuando miramos los desafíos de gobernanza vinculados a pobreza energética, la comprensión del territorio y la visibilización de cuáles son los estándares, las exigencias desde el punto de vista de los servicios, las formas de vida que hay en los distintos territorios y cómo la pobreza energética tiene una expresión distinta según esas características, aparece como crucial. Entonces, bueno, lo dejo hasta ahí para que después podamos seguir conversando. Muchas gracias.
Well, many thanks, Anahí. I think it's nice also to have different languages in the Congress. I think it enriches a bit the sessions. I think you hit the nail on the head on this question, which is that we should have information and enough information and quality information to tackle the problem of energy poverty legally. So first we have we should have the enough information and quality information. So I have some questions, but that will be later after the whole panel. And I also invite you to prepare questions if you have. We will do this later. So now I would like to ask the rest of the panelists in this third panel to come here with me. And that's Iván, Bowen, and Asmaa. And I think Natalia is online, right? Entonces, aquí. So, Asmaa, you.
Do I just, you have to click on the PowerPoint? Perfect. And then I present it. So, I see.
So first I want to present Asmaa Khadim. Asmaa is a postdoctoral researcher in institutions for conflict resolution at Leiden Law School. Her research revolves around environmental constitutionalism with a primary focus on comparative constitutional law, environmental and indigenous rights, natural resource conflicts, cumulative impact management, and government accountability. Her regional focus is on socio-environmental conflicts in the Americas, particularly in Canada, Argentina, Chile, and Costa Rica. Asmaa previously held academic positions as a lecturer in Australia, convening courses in constitutional and international law. Prior to entering academia, she worked in private practice as a barrister and solicitor in Ontario, in Canada, and her presentation is called A Citizen-Centric Approach to Evidence-Based Decision-Making under the European Green Deal. So you have the word now.
Thank you, Clara. And I wanted to start again by thanking the organizers. We've had such a wonderful time. Thank you for putting this together. And it's been great meeting so many researchers who are looking at related issues on energy transition. Of course, the dinner was amazing, and the coffee today. So lots of opportunities to have interesting conversations. So thank you for that. I think I would look forward to doing this again. The paper I'm presenting today is one that I co-authored with Hanneke van Eycken from Utrecht University, which is also involved in this Institutions for Conflict Resolution research project. So she's part of the same research group. And the paper is basically looking at evidence-based decision-making under the European Green Deal. So in relation to the theme of this colloquium, we're looking at the question of whether legal orders support a socially and ecologically just energy transition. And we hear this term just transition as you just mentioned as well, a lot in relation to the Green Deal. Is it just and inclusive? So what this concept, what is just is actually a concept that requires further elaboration. But first, just a bit of background about the European Green Deal for those who might be unfamiliar with the specifics. The Green Deal is a really ambitious plan that envisions a profound transformation of the EU economy to achieve climate and sustainability objectives. It has a goal of achieving net zero emissions of greenhouse gases by 2050, decoupling of economic growth from resource use. It's actually framed as a growth strategy, one that actually seeks to transform the EU into a fair and prosperous society that protects the EU's natural capital and the health and well-being of its people from risk of environmental harm. The Green Deal actually refers to its policies as deeply transformative, and it anticipates pretty widespread impacts on communities and industries across Europe, from energy supply, production and consumption, to large-scale infrastructure, transport, food and agriculture, construction, taxation, and social benefits. So it really promises to affect the lives of just about everyone in the EU. So when you think about what they're envisioning, deeply transformative, we're talking about really changing society in a fundamental way. Despite its ambitions, though, it has also been the subject of concern and at times fierce criticism. And there are concerns on a number of issues, including whether it can actually meet its environmental objectives, whether it can meet its economic objectives. There are also allegations that it externalizes environmental impacts, as we talked about yesterday. And also that it might prioritize private investment over public interest, that it places blind faith in technology and facilitates greenwashing. Because of the diversity of the European economy, the Green Deal will necessitate more drastic changes in some places than others. So that also leads to concerns over disparities in its application and maybe potentially increasing regional inequality. And of course, then there's the risk that it can exacerbate pre-existing societal tensions and then result in deep conflicts with communities. So in our work on institutions for conflict resolution, we're looking at the drivers of conflict and also possible solutions to mitigate or prevent these types of conflicts. So with this just and inclusive approach that's envisioned in the transition, the Green Deal talks about putting people first, paying attention to regions and industries and workers who are going to face the greatest challenges. It talks about active public participation, how the public has to be confident in the transition in order for it to be successful. And it also highlights the need for careful attention to potential trade-offs between economic, environmental, and social objectives. Stating that it'll be guided by the European Pillar of Social Rights in ensuring that no one is left behind. But then this raises some really important questions about how policymakers will strike the right balance. How will social and human rights impacts as a result of these sweeping new laws be taken into account in the decision-making? For example, the Green Deal contemplates a transition to green jobs. So a just approach would require considering age-based discriminatory impacts on workers who will be unable to transition to new employment. To give another example, the Supreme Court of Norway stripped wind farms of their operating licenses in 2021 due to violations of cultural and land use rights of the Sami, so there were indigenous impacts. These groups also inhabit Finland and Sweden, so how will those potential impacts be addressed? How will they be assessed? So with the emphasis on climate and economic data, when we look at the Green Deal, they're really focusing on climate data, on economic data, but we have to consider what other types of evidence have to be included for policymakers to really figure out, how to strike the right balance, to avoid taking a technocratic style of decision-making. So to answer these questions, this paper takes a legal doctrinal approach, essentially to assess the evidentiary basis of the Green Deal decision-making and to make recommendations for just and inclusive transition. So in our research, we drew inspiration from impact assessment because it's carried out in large mining and energy development projects. And specifically, we looked at social and human rights impact assessment and what that could offer for Green Deal decision-making. Before turning to the recommendations, it's really important to consider the decision-making process that actually gave rise to these measures. So it's the Green Deal is basically an overarching EU strategy communicated by the European Commission in 2019. The first binding legislative instrument adopted pursuant to it was the European Climate Law, which was adopted in 2021. The Commission is also considering a new package of legislative proposals under the Fit for 55 package to basically reduce net emissions by at least 55% by 2030 compared to 1990, with the intention of actually making Europe the first climate neutral continent by 2050. So they've tabled lots of legislative proposals as part of this package, including a social climate fund to provide income support to vulnerable households and also to member states to help them with emission reduction measures and technological investments. And these proposals are currently working their way through the legislative process. The Green Deal's plan, as I mentioned, is really dependent on scientific data and complex data from the Intergovernmental Panel on Climate Change, as well as economic data. But there is a need to pay careful attention to the potential trade-offs between economic, environmental, and social objectives. So if we're going to figure out how is it that no one will be left behind? And what is a just transition? We need to do something more than simply develop economic measures that address one particular type of impact. So looking at what else we can do, in trying to determine potential solutions, we thought a lot could be learned from the world of impact assessments, particularly from the resource sector. And why mining? Well, major resource projects have a significant impact on local communities and economies. The scale of the impact can sometimes be so big, so they've, as a result, had to develop these tools and processes to effectively assess and then mitigate and manage these impacts, and potentially even improve community well-being. So lately with impact assessment, there's been more focus on actually improving community well-being. So contemporary impact assessment tends to be more participatory these days. They've taken a more inclusive approach that sort of recognizes different types of knowledge and the importance of representing diverse societal views. And even though the results of impact assessment still leave something to be desired within the mining sector, I think it still offers a lot in terms of this discussion. We don't have too much time to get into social and human rights impact assessments and what they are, but essentially social impact can include anything linked to a project that affects or concerns impacted individuals or stakeholders directly or indirectly, whether experienced or felt in a perceptive, cognitive sense or in a corporal bodily sense. So anything can be a social impact. And some examples are on the slide: culture and way of life, community cohesion, stability, impacts on political systems, fears, aspirations, expectations, and of course, various aspects of various types of human rights. So you know that even though fears and aspirations might not be based in fact or in reality, they can still affect how a project unfolds. So if you identify and mitigate these impacts, then you can go a long way towards ensuring the success of your project. So what does this mean for Green Deal decision making? Well, we have all of these tools that can really assess social and human rights impacts in a concrete way that is participatory and inclusive if done correctly. And they can provide key information and evidence to decision makers in their determination of what is just in the green transition. And we're essentially arguing that this critical data should be informing the European Green Deal's decision-making process at every stage, which would actually mean mapping out the stages of social and human rights impact assessment onto key decision-making stages, from policy-making to legislative enactment, all the way through implementation on a sector-by-sector level or project or community level. Impact assessment is already required for Commission initiatives, and so in accordance with the better regulation guidelines, some impact assessments are undertaken, and a number of impact assessments were undertaken prior to implementing the Green Deal. But the issue is a lot of them focused on impacts on employment or household costs, so it was a very economic focus. And I think if you reframe and broaden this mandate to comprehensive social and human rights impact assessment, we can really go a long way towards addressing this question of what is just in the transition and mitigating conflict. I don't know if I'm within 12 minutes or, okay, I'll stop here.
Okay, thank you very much, Asmaa. I think this was very great. And I think this issue is important both for lawyers and non-lawyers to keep in mind. So now I'm especially happy to introduce Iván Hortigüela, especially because we were classmates during the career. So I'm glad to introduce you today. Iván Hortigüela Bolsa is a lawyer specialized in environmental law, and he's a PhD student in industrial modality at Insta Serveis Jurídics Ambientals. And and Universitat Rovira i Virgili. In recent years, he has provided legal advice on a wide range of environmental matters, including disputes related to the implementation of renewable energies. And he's also currently investigating the phenomenon of illegal trafficking of plastic waste and the criminal liability of the legal person. His presentation is entitled La protección legal del territorio catalán ante determinados proyectos de energías renovables, so the legal protection of the Catalan territory in front of some projects of renewable energies. So the floor is yours, Iván.
Hi. First of all, thanks, Clara, for your kind introduction, and thanks to the organizing committee, to the scientific committee, to the CEDAT, and to the IDAT for allowing me to be here. Today, I will talk about the legal protection of Catalan territory against certain renewable energy projects. First of all, I will expose a super quick overview of the status of the implementation of renewable energies in Catalonia. Then we will see a case study which exemplifies some bad practices in the implementation of renewable energies. And from the current situation and the case study, I hope we can reach some valuable conclusions, not only in Catalonia. In January of 2020, the state of climate emergency was declared in Spain. Among other measures, the Spanish government marked as an objective to achieve the 74% of the energy generated from renewable sources by 2030. Catalonia specifically developed a regulation in November of 2019 in order to impulse the deployment of renewable energy. During the last 3 years, hundreds of projects have been submitted in Catalonia. We also have to consider that Catalonia has 4 provinces, but the most part of the wind turbines are installed in the provinces of Tarragona, 64% of more than 800 wind turbines, and Lleida, 22%. Likewise, the most part of photovoltaic solar farms are placed in the province of Lleida. By May of 2022, I can say that more than 100 wind turbines and more than 2,000 hectares of solar photovoltaic farms are on the way to be authorized, mostly in the provinces of Tarragona and Lleida, respectively. The concentration of energy projects in specific areas of Catalonia, the environmental and social impacts that them may cause, and the fact that part of the energy generated is not consumed in the surrounding areas has generated a strong opposition of some sectors of the community. Even local administrations and municipalities have opposed against certain projects of renewable energies. And last but not least, recently, European Commission has launched the Repower EU plan, which will accelerate the expansion and the deployment of renewable energies in Europe. It seems that the conflictive situation will last at least some years. From what I've seen in my daily work, the projects often present legal and environmental defects. In January of 2021, a local administration contacted us in order to analyze if 3 wind energy projects were legal and environmentally viable. The ubication of these projects is what you are seeing in the screen in the province of Lleida, but very near from Tarragona. In my presentation, I won't mention specific towns or cities or the real name of the projects or even the name of the companies in order to preserve the professional secret. I will also explain this case and not other because it's a good example of the most common bad practices that we've seen in Catalonia. There are projects far better elaborated than these 3 and others that may be in a similar level or even worse. And I have to make it clear that this presentation is not by any means a discourse against renewable energies. or companies that make profit of renewable energies. Project A was composed by 9 wind turbines and had a total power of 49.5 megawatts. Project B was composed by 5 wind turbines and had a total power of 27.5 megawatts. And the last one had the same characteristics as Project A. All the projects were intended to be located at non-developable terrains and need the construction of various kilometers of roads in order to access to the final placement of the wind turbines. All projects were intended to be located in adjacent towns very near to each other, and they also were intended to be developed by affiliated companies, members of the same group. The 3 projects also shared the same energy evacuation system, and the Project A also contained references to a high voltage line that was intended to be authorized with the same Project A. Our law firm analyzed the and elaborated an inform for the local administration that contact us with all the environmental issues that we detected, the town planning compatibilities, and the potential illegalities. Among the environmental impacts, we found that the 3 projects were intended to be placed in an area with multiple signings of Aquila fasciata. The Aquila fasciata is a protected species according to European Union Directive 2009/147/CE on the conservation of wild birds. We also found room for discussion around the qualification of the ground. Most of the ground that was going to be affected by the wind turbines and the roads was qualified as forestry ground or agriculture ground by the different town plannings. The construction of wind turbines wasn't one of the allowed uses of these grounds, but neither was prohibited, so there's room for discussion here. And another town planning limiting factor, this one more clear, is the impossibility of building new roads. The 3 projects, as I said, need to build new roads in order to set up the wind turbines. Some of the affected towns only allow, according to their planning, to build new roads if these were contemplated to be developed by the town planning or in special developing plans. We studied that factor and we detected that nor the town planning or the special plans contemplated the development of these roads. And last but not least, we have some procedural infringements. The 3 projects shared energy evacuation infrastructures, were meant to be placed next to each other, and were meant to be developed by companies of the same group. If we study this situation closely, we can see that there's no 3 projects, that there's only one big project that was intended to be fragmented. The fragmentation of big projects is considered by Spanish courts of law as a cause of illegality, and the fragmentation of the projects also implies most of the times the fragmentation of the environmental impact procedure. And finally, Project A included a 8-kilometer high voltage line that connected all the projects with the province of Barcelona. We discussed that question. We explained that the high voltage line was intended to be object of other procedure, so what happened? Our analysis was presented by the administration that hired us to the Ponencia of Renewable Energies. But what is the Ponencia? Well, it was a board composed by some administrative representatives with environmental responsibilities, energy responsibilities, town planning or agricultural responsibilities. One function of the Ponencia was, but not anymore, to decide before the environmental impact assessment procedure the request of the administrative authorization and the approval of the urban project if the selected emplacement of the projects was viable or not. And if declared not viable, the administrative procedure should stop. So, Project B and C were declared non-viable and Project A viable under certain conditions. Project B and C were considered to have several affectations in bird life, like Aquila fasciata, but other aspects were studied, but this one was the decisive. There was no pronunciation about the fragmentation of the project or the town planning aspects mentioned. And finally, Project A was declared viable under certain conditions. These conditions was to modify the route of the high voltage line in order to not affect to the vital spaces related to bird life species like Aquila fasciata or golden eagle, the Aquila chrysateus. And with that, I will finish some pretty basic conclusions that we can extract from the current situation and from the case from cases like this one. The study and consideration of social and environmental impacts is key. The concentration of projects in specific areas not only has potential environmental impacts, as I exposed, but also generates the opposition of the community. The position of the community, the intervention of environmental NGOs can slow down the deployment of renewable energies through public participation and judicial procedures. Another conclusion, and this one is vital, companies should study in detail the viability of the project before they start the administrative procedure. Otherwise, they may end up not being authorized, which slows down energy transition and also suppose a waste of administration resources. And last but not least, the implementation of renewable energy projects needs a detailed planification if it wants to be fair with all sectors of the community. Thank you for your attention.
Thank you, Iván. There's this motto from activists and platforms that is getting famous. It's renewable, yes, but not like this, no? Like how we use renewable energy, no? For example, in Terra Alta, there's 25% of the wine farms, no? It's a very, very small territory in Catalonia, and it's getting 25% of the wine farms. It's yeah, maybe it's not well distributed, right? So now it's the turn of Bowen Gu. Bowen is a PhD student at the Institute of Environmental Science and Technology in the ICTA, in the Autonomous University of Barcelona. Her research looks into coal-related environmental justice movements in China and broader regions under the Belt and Road Initiative. She received her degree in mathematics and physics from Tsinghua University in China and her master's degree in with an Erasmus Mundus in environmental sciences, policy, and management. And prior to starting her PhD, she worked for multiple years in socially responsible investment to help investors integrate environmental and social issues in their investment. So her title is Environmental Public Interest Litigation, a legal pathway for environmental justice and energy transition in China. Well, that would be the question, no? More than a sentence. So you have your time now to speak.
Thank you very much, Clara, for the introduction. And also, again, thank you to the organizers. It's been the third year I followed TIEC and the previous 2 years online. So it's really a pleasure to be here in person and present my work in progress on environmental public interest litigation and environmental and energy justice in China. So as part of my PhD, I'm also a member of the Environmental Justice Atlas group. And it was really a pleasure yesterday to hear some participants already use the data from the EJ Atlas or even contributed to EJ Atlas before. So I hope we can also expand more on the collaboration with more legal researchers and practitioners in the future around the world. And for my own research, I use EJ Atlas as a database for data collection on environmental justice movements, as well as using the framework of EJ Atlas with the variables that are embedded in the database. So this 2 days, we discussed a lot on renewable energy from hydrogen to wind. And I feel really bad to throw in like a bomb to discuss the kind of dark future still existing in front of us and on the other side of the world in China. And just to give an idea about the scale of the issue out there, that in 2020, for example, amidst the pandemic, China built 70% of the coal power plant in the world. And just borrowing the illustration from Global Energy Monitor, this basically, and this is a trend that's still ongoing. And with the newly proposed coal power plant in China, this basically offset the amount of reduced or retired coal power plants outside of China around the whole world. So bearing that in mind, I started my PhD, like Clara already mentioned, at the EJLS team, and with a role, an objective to investigate the role of bottom-up initiatives in opposing related impacts of coal-related industries and their role in influencing environmental and climate justice in China. And both in China and around the world, the impact of the coal sector is actually well studied already. And it's also very much, a lot of empirical evidence can already be seen in the AJLS also around the world. And it's worth to mention that it's not only just coal mining and coal power plant, but also extends to coal chemical industry, for example, because with the retreat of coal, more and more coal producers are going into converting coal to oil and gas. And this is even also more problematic compared to coal itself. And so what brought my interest to public interest litigation? So on the global level in AJ Atlas, actually more than half of the cases involve some sort of legal strategies. And it also can be seen from a research my colleagues done on a global level that when complemented with other tactics, litigation can also enhance the success rate of environmental justice movements. And to put it into China's context, traditionally civil society tends to not confront directly with the state, the government. So when this revision of the environmental protection law allows NGOs to participate in public interest litigation, people argue that it actually opens a new door for NGOs to pressure state actors and also enhance regulatory compliance or even to influence legislative reforms. And so with that, I would like to also share a bit more about the development of this space in China for those that are not familiar with it. So some important milestones include in 2012, there was a revision of the civil procedure law, which for the first time included civil public interest litigation in the system. But because there was lack of clarity, many of the cases that were filed were actually rejected by the court. And in 2015, this new environmental protection law that I mentioned for the first time allows social organizations with more than 5 years of existence in environmental aspect to be eligible for filing public interest litigation. And so this year of 2015 is also considered as the very first year of the existence of environmental protection, environmental public interest litigation in China. But following this, there was also more legislative efforts, but that focused more on the procurator's side to encourage them to participate in public interest litigation. And some people may argue that this actually, to some extent, limits the space for NGOs to file such litigations. And also later on, the system of equal compensation system that allows administrative agencies to file litigations also to some extent contradicts or affects the NGO's role in this. And I will mention that in some specific cases later. So with that, I added to some extent a sub objective for my PhD research to investigate more specifically the co-related public interest litigation filed by NGOs and their role in influencing environmental and climate justice. And I used both secondary data collection and also combined with field work in China, interviewing different NGOs to collect the data for case studies. And I used two major databases from the Supreme People's Court in China to filter the coal-related cases and also using NGO's newsletter and annual report to further complement the case studies. And so with that, I came up with a total of 44 cases across the whole core value chain. And it's interesting to look at the geographical distribution of these cases. And it's heavily spread across the northwestern of China, and to some extent also manifests the inequity, the inequality of environmental and social issues that are shouldered by the communities in these regions. And this trend also corresponds with the co-production trend in China. For example, like the top co-producer provinces in Mongolia and Shanxi has the highest number of cases, whereas most of the other top co-producing provinces also have at least one cases. And looking at who are the NGOs filing such cases, over the years, there's gradual increase, but it's a bumpy progress. So, of course, in 2016, after the new law came into force, there's an increased number of cases. And in 2019, there were increasing number of cases on the coking industry. And I feel that's more actually a low-hanging fruit for NGOs to file such cases, because it's more obvious and more easier to collect evidence of pollution of such companies. Whereas for the NGOs, it's a combination of government support NGOs, which is highlighted in yellow background, and also grassroots NGOs. And it's also worth to note that all of these cases are filed across cross-province, meaning either the NGO is located in the capital city of Beijing and they file a case in another province, or they are local NGOs in another province and filing against a company in another province. And this, to some extent, my assumption for this is that there's a heavy phenomenon of local protectionism in China, especially for this coal industry. It's heavily state-owned enterprises. And so for filing cases across province, it is kind of a safe approach for NGOs. And for the causes of these cases, its majority is air pollution, and also complemented by some other forms of pollution that are mentioned. But very or almost none case mentioned the climate impact in particular in their cases. And for the most importantly, about the outcome of these cases, a lot of them actually resulted in settlement with the companies, but this also result in large amount of remediation costs that the companies need to shoulder as part of the results. And also a large number of cases are actually still pending after multiple years, and showing some of the procedural justice challenges faced by NGOs. And just to share a few specific examples, like the first one, this is a case where an NGO in another province filing public interest litigation against 3 mining companies in Mongolia. And this was actually started not from a legal perspective, but an artist tried to intervene in the local environmental justice movement to help the local communities whose drinking water was polluted by the mining activities. And to some extent, this is a follow-up of the environmental justice movements by local communities. And the second case is an example of how an NGO, this is actually a government-supported NGO that sued both a company and the natural resource department of the province. And this is one of the few examples of NGO trying to file the public interest litigation not only against a company, but also an administrative agency. But this faces a lot of challenges because their legal standing was not recognized in filing such administrative PIL case. And the third one is an example where it shows collaboration between NGO and the prosecutor's office. So it was with support from the local procuratorate. But what's sad is that it was overlapping with what I mentioned earlier about the equal compensation system that enabled the Environmental Protection Bureau to file this environmental damage compensation litigation against the company. Although they filed it later than the NGO's case was withdrawn in the end. And the last example I want to show is actually considered one of the first semi-climate litigation example in China. That is the first grassroots NGO in China, Friends of Nature. They sued the state grid in 2 provinces for not purchasing the wind and solar energy produced, and which to some extent caused more pollution from coal-fired power plants. And so with the time limit, I would come to the final discussion. I think there's also opening up more questions instead of conclusion in reality. But like yesterday, Leah mentioned, when there's a problem, it also opens up more opportunities. So I hope it will also open more opportunity for further research on these questions and for NGOs to participate in this form of public interest litigation. And so one issue is with NGOs' participation in this is how effective is their participation on, and also there are some cases that resulted in a large amount of settlement, but there's no follow-up of monitoring of how such money is used for actually recovery or of the damage. And like another question yesterday mentioned about, for example, strip mining, and with the large amount of finance needed for further recovering of the post-mining area. And it also needs more efforts from the collaboration between NGO and other stakeholders in the government or procuratorate to enforce such follow-up. And the last point I want to mention is that in the broadly in the global south, it is considered that the countries are taking more of a stealthy approach towards climate litigation, with the limitations in some jurisdictions. And so in China in particular, it's more opportunity to explore the synergy between what is already happening in public interest litigation, which is on pollution control and climate justice. So with that, I want to conclude my presentation. And I also want to mention that a lot of NGOs in China are still working very hard to try to find different pathways, including public interest litigation, to do climate litigation, and happy to share more or receive feedback from other people that has more experience in this field. Thank you.
Thank you, Bowen. I think that you open up a melon and then a lot of melons appear. But I think it's good in research, so I encourage you to keep doing this research.
Thank you.
And good luck. So now we have the last panelist of the panel and of the Congress. I would like to present. This is a multiple panel. Well, I will come here and maybe. Hi, Natalia. You see us?
Hi, yes, I
Hi.
see you.
And
you
we listen to you.
hear me
Okay, so I want to present Natalia Urzola, Co-Chief Operating Officer at Global Network for Human Rights and the Environment, who is presenting a panel, in-group panel with Maria Antonia Tigre from the Global Climate Litigation Fellow at Sabin Center for Climate Change Law at Columbia Law School, Milagros Mutsios, who holds a master master in law, who is a master in law candidate at Yale Law School, Lorena Centeno, a PhD student at the University of Edinburgh, Marlies Hesselman, lecturer in international law at the University of Groningen, and Riccardo Luporini, postdoctoral research fellow in international law in the Sant'Anna School of Advanced Studies. The title of the panel is of the presentation is Just Transition in Latin America, Striking a Balance Between Economic Development and Environmental and Social Energy Justice. So, Natalia, the floor is yours. If you want to share, do you have a presentation?
I do, yes. I wanted to ask you about that. I should just share it here, right?
Yeah, that's it.
Are you looking at the presentation?
Yeah, we see it. We see like a background. Maybe you can, yeah, perfect. Now it's perfect
Okay.
and we hear you. So when
Okay, that's great. Thank you so much, and thank you and the organizers for organizing this colloquium, the fantastic colloquium, and for the opportunity to present today our work in progress. So I'm gonna be talking on behalf of my co-authors about this work in progress that took place or started within the global network of peer-reviewed scholars on climate litigation that is part of the Sabin Center for Climate Change Law at Columbia Law School. This is a network of over 70 scholars from 50 different jurisdictions, and including 9 international or regional adjudicatory bodies. And within that network, a subgroup was formed where we started to analyze and discuss just transition within climate litigation. And the main focus that has been placed so far within this subgroup is on Latin America's experience and seeing that studying Latin America as a potential forum for significant lessons as we, the whole world, move forward in the energy transition. So with that in mind, we started to think about the concept of just transition and what it entails. As we all know, there is a pressing need to reduce greenhouse gas emissions and mitigate climate change, which has driven society to phase out of fossil fuels, as a lot of other panelists in this colloquium has already mentioned. Yet, these decarbonization strategies are developed within a context of significant socio-economic challenges, including inequality and racial injustice. According to the International Labour Organization, keeping global warming below 2 degrees Celsius could create 18 million net jobs worldwide. However, the transition away from fossil fuels could also result in the loss of 6 million gross jobs by 2030, which will be overwhelmingly in the energy sector. So in order to succeed, the energy transition has to be fair and just, and has to provide opportunities for both workers and communities that are currently dependent on fossil fuels. The Paris Agreement called for national plans on climate change to include just transition measures as central in their strategies for climate action. Just transition is a twofold concept in the sense that it has environmental and labor-driven dimensions. It could be defined, just transition, as a shift towards a low-carbon society that ensures protection of minorities and carbon-dependent communities from the undue burdens of decarbonization costs. The 2022 IPCC report on mitigation placed a specific emphasis on how inequalities in the distribution of emissions and the impacts of mitigation policies within countries could affect social cohesion and the acceptability of mitigation and other environmental policies. So with that in mind, we identified these 3 main aspects of just transition, namely decent work, clean environment, and universal access to basic goods and services such as energy, transport, and water. These 3 aspects are deeply or directly related to the 3 main principles that some scholars have already started to discuss that entail or that are embedded within the concept of just transition. So transitions are inherently disruptive, and there is a pressing need of making deliberate efforts to ensure that communities that are dependent on fossil fuels do not suffer disproportionately. So there is an implicit notion of equity, well-being, and justice within the broader just transition concept. Now, Turning over to the Latin American experience and taking into consideration the Paris Agreement call for action, we started to look into the Latin American countries' national determined contributions just to see what is there. And what we found was that even though all Latin American countries have ratified the Paris Agreement and have started to develop climate change mitigation and adaptation measures, only 2 of Latin American countries have an explicit mention of just transition within their NDCs, and these are Chile and Colombia. Chile includes both just transition and sustainable development as a central pillar in their NDCs, and Colombia does mention the just transition in the workforce with a focus on the protection of the environment, indigenous people, and other marginalized groups. And what we saw in this first approach that we made to the Latin American NDCs is that the main focus is on the energy sector, and nothing has been yet said on the agriculture or forestry sector. And the just transition mentions are mainly concerned with employment and are excluding other issues such as social issues, protection of vulnerable groups, gender identity, among others. So that takes us to the role of climate litigation within this broader energy transition. As we all know, climate litigation is a novel and rising phenomenon within litigation, and most of the cases that are known are what we can call pro-regulatory measures, that is, pro-regulatory cases, that is, cases that are either wanting to enact new and more ambitious legislation or enforce existing legislation. But there is also another set of climate litigation which can be called, or has been called by some scholars, as anti-regulatory cases, where the aim of these lawsuits is to delay or dismantle existing or emerging regulatory measures for climate change, reacting to the regulation that promotes climate action. It is important to mention that this doesn't mean that these type of cases are against climate action per se, rather that they want to be mindful and place focus on other issues that are being overlooked often in the pro-regulatory cases, such as human rights violations. Just transition climate litigation cases are part of this subset of anti-cases grounded on human rights questions. Climate concerns are typically peripheral or incidental, but nonetheless, they are instrumental in the development of climate action within each jurisdiction. So just transition cases in Latin America can show us ways to move forward in the just transition, in the energy transition, sorry about that. Just transition cases in Latin America rely on, in whole or in part, on human rights violations, and they are questioning the distribution of both benefits and burdens of the energy transition. In Latin America, we have a complex situation of, on the one hand, the relationship between energy supply and economic development, and on the other, the need to protect the environment, the need for social justice, and the need to protect and enjoy human rights. Most cases in Latin America could be categorized in 2 types of cases. One related to the decommissioning of existing fossil fuel projects, where there's already labor force engaged in, and there's a need to relocate that labor force, or cases related to new technologies that are needed for renewable energy projects, such as mining, activities related to lithium for batteries and other things. In these cases, indigenous and traditional communities continue to be impacted by mining activities and or the installation and transmission of renewable energy. So today, I'm just gonna briefly talk to you about 2 cases, one from Chile and one from Mexico. This is a very broad overview of the cases, just highlighting like main conclusions that we have found so far that we believe could help in this further research agenda on just transition and energy. So the case from Chile was brought by workers that argued that energy decarbonization agreements were lacking the participation of the mining workers that were being affected by those agreements. The Supreme Court ruled that the closure of coal-fired plants is part of Chile's energy sector decarbonization plan to achieve carbon neutrality by 2050, but the Supreme Court also emphasized the need to include the harm that workers are experiencing and the loss of their direct and indirect source of income and employment for those workers and also for the communities dependent on these industries. So the Supreme Court ordered a plan for reinsertion in the workforce of the workers that were acting as plaintiffs in this case, but with the specific need to consult them in that process and to adopt measures that would ensure compliance. As we see, the focus here in this case was mainly on labor and the economy. The other case that I wanted to bring today, it comes from Mexico and relates to the construction of a large-scale wind farm by a private French company on the lands of the Zapoteca indigenous people in Oaxaca, Mexico. In this case, the community was not against the wind farm project. Rather, what they are claiming is that even though the energy is being produced in this project, it's being used directly and mostly by large private companies and is not being used to alleviate energy poverty. They also claim that the project is aggravating, I'm going to come to an end soon. They are also claiming that the project aggravates people's access to energy and decent life by placing pressure on indigenous livelihoods to the encroachment of their productive lands. And finally, they also brought up the labor dimension of the just transition too, mentioning that these type of projects usually insist that they are going to be beneficial by creating new jobs. Yet, if not taken further consideration, these jobs are mainly temporary, low paid, and do not extend beyond the initial construction phase. So the focus here is mainly on labor, energy, and energy poverty and the lack of access to it. And that's precisely like what we believe is relevant to bring to the conclusion. We had another case, but I'm just going to go to the conclusions in the interest of time. So these are our main 5 conclusions that we have come to so far. And first of all, we see that Latin America, although there have been few cases and most of them are still pending, so the full impact is yet to be seen, we do believe that from the decisions that have already been taken or the lawsuits and the claims that are being presented, we believe that this is an opportunity to delineate some of the questions, like the broader questions on environmental and climate justice that affect just transition worldwide. We also believe that Latin America presents a particular experience that is sometimes conflicted due to their over-reliance on extractivism. So even though Latin America presents as a region that is like in the forefront of climate action, they still most of the countries, I cannot generalize, but most of the countries still rely on extractivist activities, which kind of like contradicts their eco-friendly rhetoric. Another aspect that we believe is important to highlight within this concept, within this context, is that this just transition litigation could help prevent social conflict. As was mentioned by one of the panelists before me, this type of transitions that are disruptive could fuel old or even create new conflicts, social conflicts that need to be addressed and need to be taken into consideration when advancing and moving forward with the energy transition. We also believe that Latin American experience with resistance is one that should be one of the main lessons that should be considered as we move forward. For many years now, labor unions, social movements, and indigenous communities in Latin America have been instrumental in remaking political economies. There's massive resistance from indigenous and working class communities to extractive developments, even as of today, and it is only getting stronger. And most of these movements have like environmental and climate justice at its core. So we do believe there's like an opportunity to learn from them as we move forward. And finally, we believe that COVID-19 was presented both as a setback as and an opportunity to engage more with the Green New Deal or the Green Deal or any type of proposals that include this energy transition with a environmental and climate justice at its core. The pandemic brought together voices in favor of advancing this transition, and it could allow for a possible collaboration between governments and sectors. So with that, I want to close. These are my co-authors, my co-contributors. I just want to acknowledge them as well, and I look forward to your questions. Thank you so much.
Thank you, Natalia, and the whole team. I see some of you that you are also connected, so many thanks. So now I would like to invite Anahí to come here with us again. We are a bit out of the time, but I think we can adjust the time to the 25 minutes that we had scheduled. And yeah, so we can start the debate and part. You know that you can post the questions in on the chat, or also raise the hand if you want to talk on the microphone, or also here in the room. Okay, if there are questions, already questions, we will give you the microphone. I think Andrews wants to, well, has a question. Also Pia. Okay, also I have questions too. So Andrews. Or I didn't see Leah. Okay. So Leah, Andrews, and then Pia. Is it okay?
No.
Okay.
Hello, everyone. This has been a really impressive panel, so congrats to all of you. I have several questions, but I'll try to contain my curiosities only to just a few questions. In relation to the presentation of Professor Anahí, congratulations for the presentation. I would say that I would like to have a matrix so complex of analysis of energy property like the one that you exposed. It would be really, really, really impressive and really interesting, because I think that not only Europe, but at the international level, there is a misconception, a misunderstanding about what justice or energy justice is. Because, well, it's not just the problem of aid, economic aid to people. It's also the consideration of territorial issues. So I am absolutely agree with you. I have a quite technical question, which is, in case that some kind of vulnerability is detected, and this kind of vulnerability may be solved with an economic aid. In this case, is the private energy sector that must provide the aid, or it is to public expenditure? This is the question, because here there is a debate about who is responsible to pay for measures to alleviating energy poverty. And if I may, I have other two questions. May I abuse of the patience of the panel? You
are the first, so for the moment I will be.
Okay. So the other one is about the development of energy projects, and it is about the new REPowerEU plan. And there is a document that accompanies the plan, which is a recommendation about procedure to speed up granting. And I know that you know what is my issue is, this recommendation about avoiding the scope of the directive on habitats and so on. So the state should avoid, introduce some kind of measure to speed up procedures, avoiding that basically, if these measures are done, this is that the incidental killing of disturbance of individual specimens should not be considered deliberate, therefore should not fall under the directive of habitats and directive 2009. So what do you think about that? There is here a clear contradiction with the very spirits of biodiversity, the European biodiversity law. And the last one, and the last one is to Asmaa. Do you think that it's possible in Europe to have some evaluation of the solastalgia issue, like the famous ruling of Judge? There is the judgment in Australia, the very famous one. Now I'm losing the name, and there is into the ruling the reference to solastalgia as a social problem that should, and Preston, right? Jude Preston, about this feeling of distress caused by the alteration of the environment, personal feeling of distress. So thank you very much.
Okay, yeah. I think for the moment, if you have the answers, or you want to keep doing what? Oh, you can. Yeah. Okay. So Anahí.
Muchas gracias por la pregunta. La respuesta no es fácil, porque creo que hay una simplificación, ¿no? Cuando hemos tratado de solucionar estos problemas con solo el Estado o solo el sector privado. Mi país es el paradigma de la neoliberalización, ¿no? Nosotros dejamos todo en manos del mercado y ha sido un desastre absoluto. Pero también sabemos que hoy día con el nivel de diferenciación funcional que existe en el mundo, tampoco, por mucho que queramos que el Estado controle la economía, no funciona, ¿no? Entonces, por lo tanto, necesitamos modelos mixtos, donde al menos en nuestro país nuestra gran batalla es relevar el rol del Estado, ¿no? Porque como estamos en el otro extremo, y el rol del Estado en este contexto tiene que ver con definir las reglas del juego, las condiciones para poder desarrollar los servicios energéticos, la información que se necesita para poder abordar estos fenómenos de la mejor manera posible, la infraestructura, la inversión en infraestructura definida, ¿no? Uno de los problemas que nosotros tenemos es que quien decide qué tipo de proyectos se realizan es el mercado. Entonces, por lo tanto, los criterios para definir los proyectos son ganancias para las empresas en el corto plazo, y no hay una mirada de largo plazo. Hay sectores que efectivamente no tienen la posibilidad, no hay rentabilidad posible por dónde están, por los pocos que son, etcétera. Entonces, no es posible invertir en ellos porque en el fondo no es el Estado el que tiene una planificación, sino que son las empresas. No hay planificación del Estado, ¿no? O sea, tenemos unos esfuerzos de planificación que son más bien retóricos, como nos gustaría que fuera hacia allá, pero en realidad las empresas son las que definen y hacen, y no hay herramientas legales para ello, no hay condiciones. Por eso quiero decir que era tan importante en nuestro caso tener las posibilidades de tomar decisiones. Nosotros no tenemos la posibilidad de tomar decisiones. Entonces, claro, ahí es clave, pero por otra parte también las empresas necesitan cierta certeza jurídica de que van a poder obtener las ganancias, porque operan con una lógica económica, ¿no? Entonces tienen que, para que estén dispuestos a invertir, que se necesita la inversión y las operaciones del sector privado, necesitan cierta certeza y reglas del juego que les permitan operar. Entonces, mi respuesta sería, necesitamos mucho más Estado para que las empresas funcionen bien. Pero necesitamos ambos, ¿no? Que las empresas funcionen bien y que el Estado ponga las reglas y en el fondo intervenga, y si es que es necesario cubrir ciertos gastos, subvencionar a cierta parte de la población, lo haga, pero tampoco podemos sobrecargar el Estado con que se haga cargo de todos los gastos energéticos, porque también necesitamos que se reduzcan los gastos energéticos. O sea, la transición energética se basa en una reducción del consumo. Entonces también está este peligro, ¿no? De que si el Estado subvenciona ilimitadamente, el esfuerzo por reducir el consumo es muy bajo, ¿no? Entonces, por lo tanto, tiene que haber una combinación.
Iván, si quieres.
Well, thanks for your question. In fact, I don't have a clear answer. I think nobody has it. I think that it can affect the principle you mentioned, in the measure that it can affect species that are endemic of a specific area. Yes, it could be a contradiction, and another question that we have to take in account in this context is how the acceleration of the administrative procedures affects to public participation. Because sometimes environmental aspects are shown by NGOs, by communities, but not by the companies or the administration. So yes, I think that in one moment or another there could be a contradiction, specifically if the environmental impact assessments procedures are not restrictive enough, and especially in areas where exists a big concentration of projects.
Thank you, Andreas, for a very difficult and thought-provoking question. That's why I was smiling, because I think it's an incredibly difficult question to answer. Sure, anything's possible. The Canadian Supreme Court recognized extreme psychological distress as a result of government action as a constitutional right under its right to security of the person, which one would never have expected. And yet the courts were willing to go that far, that if government action leads to severe psychological distress, then there's a violation of that constitutional right. And then they went about establishing very strict criteria for when you can establish severe psychological distress. So you could certainly apply that reasoning in the European context if the European courts are willing to go down that path. I don't think they're quite as willing. They tend to be a little bit more conservative. But the bigger question is, When we look at psychological distress as a result of environmental decision making, it does have an impact on the project, whether or not it's to achieve climate objectives or wonderful environmental aims. So through the social and human rights impact assessment, what you're really doing is engaging with the community very early to ascertain, first of all, are there issues that are causing distress? If so, what are they? Can we negotiate with these communities? If you include them in the decision making from a ground up approach and ask them, maybe you have other solutions, how can we do this, you might mitigate some of the conflict. So that's a extrajudicial process that might actually be better than waiting till much later in the game to go to court and try to leave it to judges to figure out. So I attempted to answer to the best of my abilities.
Okay, I think that it's Pia and it's Lea, but I think that you both can make the questions and then... No, I mean...
No, it was my mistake.
Ah, okay, all the time, okay. Perfect. Sorry, okay. So it's Pia, and if anybody else has a question, I think we will pose the 2 or 3 questions so that we are on time. Okay, so Guilherme is next, and Laura. Okay, perfect. So Pia, Guilherme, and Laura, and then you can collect and answer. Okay, so Pia, you can.
Okay, thank you. I'll try to be quick. Some of my questions have already been answered, and I'm sure we can follow up later on other things. I was going for Iván. Love finding you on the other side when I'm trying to do projects. There's one little aspect of what you were saying which very much interests me, and when it comes to fragmentation of projects, I think you're probably aware that this is something every developer does. I've only seen one project where it has not been done, actually. All my other projects always break down to, and that's not my decision, right? But they always break them down to 50 megawatt fractions to make sure they can avoid the ministry, because the ministry is very slow and they want to go through the autonomous communities. This is something that we've had a very hard time advising on in the last years, because it was never that clear for us where the limits to, is this a optimization process of a businessman? Can they optimize their projects that way because that's open? And at what kind or at what point does it get into a terrain where the projects get attackable? If it leads to species being endangered, of course, please litigate. But if this serves as, how would I say, to use this to use certain formalism in order to support NIMBY, not in my backyard movements, then maybe this is also a problem. So for you, what are the limits? When can I fragment a project and when can't I?
Okay, so that now we go to Guilherme. You can prepare me well.
So I'm sorry, I have 2 questions. One would be for Anahí and another one for Bowen. So regarding the new Chilean constitution, saying it get passed on the voting, closer there or closer. Maybe just
come with us, come.
It's the position. So what should I do? Should I have it like this? Okay, so
yeah, like
sit here now. Okay, so
Reaper.
It's better now? Yeah. Okay, so I'm sorry. Saying it passes the current draft of the Constitution, do you think that might help on energy justice efforts? And if yes, why? Which part of the current draft? Because I'm trying to follow it and I think it's kind of confusion, so I would like to that. And Bowen, would be a curiosity. Do you know if any of the cases cites that concept of the Chinese Constitution of ecological civilization? That would be just a curiosity. So thank you.
Perfect. And Laura?
I apologize, but I think I asked my question in Spanish. So, es una pregunta para Anahí. Bueno, en primer lugar, gracias porque me ha encantado tu presentación. Creo que has tocado muchísimos puntos de interés y solo con cada punto pues habría que abrir un debate entero. Bueno, en realidad ya has contestado la pregunta cuando estabas hablando con Andrews, pero me gustaría hacer una reflexión. En España, bueno, últimamente, desde siempre, pero se está empezando a hablar ahora de pobreza energética junto con transición energética. Como decías tú, pues hasta ahora se habían visto como dos dimensiones distintas y en cambio ahora sí que están empezando a juntarse. Esto, por ejemplo, está pasando con el Pacto de los Alcaldes para la Energía y el Clima, que está, digamos, se está introduciendo esa vertiente de la transición energética en los PAESC, en los pactos de, bueno, en los planes de energía y clima locales. Y a mí me parece que vamos tarde y que es una cosa estupenda. Pero, por otro lado, sí que veo que, por ejemplo, bueno, en España, las medidas del Estado para paliar la pobreza energética, porque no se acaba de un día para otro con la pobreza energética, son medidas justamente paliativas. Es decir, lo que está haciendo el gobierno y lo acaba de hacer ahora con el último Real Decreto Ley de medidas por la guerra en Ucrania, son medidas prestacionales, es decir, o dando dinero a las familias que lo necesitan, que me parece muy bien, o rebajando determinados impuestos. Pero claro, a esto debería añadirse, ¿no?, también unas medidas que sean de ayuda constante, es decir, que acaben con la pobreza energética de raíz. Por ejemplo, asumir los proyectos de autoconsumo de energía para las familias que lo necesiten, ¿no? Y que esto lo asuma el gobierno, porque claro, esas familias a lo mejor no tienen la posibilidad económica de financiar, ¿no?, o que les den un préstamo para financiar esos proyectos. Entonces, claro, creo que pues siguiendo por esta dirección, la de las medidas paliativas y de las ayudas, y si esto se acaba así, es decir, si no le añadimos a esto también las medidas, ¿no?, de ayuda, en sentido de ayudarle con el autoconsumo, ayudarle ¿no?, acabando antes que se produciera la pobreza económica, la pobreza energética, pues creo que vamos mal, ¿no?, y que no es este el camino que tenemos que seguir. Bueno, mi pregunta era, ¿qué está pasando en Chile? Bueno, ya has contestado que no hay una perspectiva por parte del gobierno, así que bueno, no te hago la pregunta, pero creo que es interesante ese punto de reflexión. Y gracias otra vez por tu presentación.
Genial, pues muy bien. Perfecto, sí. Una más. Y entonces ya vamos a contestar para ir bien con el tiempo.
Hi, Ron again, and this is a question for Bowen. So more of a political science / governance side of things. So China's known really well, or sort of very famous for central planning of initiatives. So coal-fired plants and all that sort of stuff have to gain the approval of the central party. I find it curious that they've gone and recognized NGOs as litigants to be able to get involved in perhaps slowing some of these projects down or contesting them. What motivated that policy change that allowed this sort of capacity for citizens to coalesce and start to challenge some of the central planning decisions? If you feel like answering it, obviously you don't have to.
Ok, pues creo que es Iván, Anahí, Bowen, si no me equivoco.
Okay, first of all, thanks for your question. It's a very interesting point, especially about the NIMBY effect that we all know. Well, first of all, about the fragmentation of the project. When can you tackle a project because it has been fragmented? There's jurisprudence that reckons that you can tackle that project when there's shared evacuation infrastructure that flows the energy of the same projects. And also there are other aspects to be considered. The projects are promoted by the same company or by companies of the same group, especially companies made up only for that project. And the projects are placed next to each other, are maybe within 10, 15 kilometers to each other. Personally, and it's my opinion, I may be wrong, and if people think I'm wrong, please let me know. I think that the attitude to try to be submitted to a certain law in order to not be submitted to another law could be considered as a fraud of law, in my point of view. And then count that the fragmentation of the project could also imply the fragmentation of the environmental impact assessment. And that's a point to take in count. I think that it's a huge point to take in count. And courts of law, if exist fragmentation of the environmental impact declaration, have declared projects to be invalid. Well, how does this links to NIMBY effect? We have to. I reckon that it's an effect that may exist in some places, but in my point of view, in my professional practice, I have only assessed entities of province of Lleida and province of Tarragona. And I invite all the people that are today listening that they Google in visor de la ponencia de las energías renovables in Google Imágenes, because there's a new one, and you can see where is all the concentration of the projects. Could be an NIMBY project, could be, but most of the times our clients say, well, in our town, we have already 30 windmills and they want to put 10 more. This happens. And we have to think about the NIMBY project, but the NIMBY effect, but we have also think if the ubication of the projects is based in an environmental aspect, to be respectful with the environment, or in an economic aspect. It's more cheap to place that project in Terra Alta than in Barcelona. We have to think about that. Which is the criteria behind this decision? And we also have to think about the energy that it's produced in determined places. Where does it goes? It's consumed in the surroundings or not? Well, I don't know your question, and I expect to be kind in my answer. It was not my intention to be rude at all.
Sorry, I'm really sorry. I mean, you will answer. Maybe I suggest that you speak like 4 minutes each one, so that we are, if you can try. Anahí, yes.
Ok. Brevemente, entonces, las dos preguntas que me hicieron. Voy a partir por la última, por el comentario. Efectivamente, yo creo que es uno de los grandes desafíos. ¿Y por qué es tan importante abordarlo en conjunto y no pobreza energética por un lado y transición energética por el otro? Porque si abordamos solo pobreza energética sin mirar las condiciones de transición energética, podemos agravar los problemas que tenemos, ¿no? Y sabemos que eso ya no es viable. Entonces, por lo tanto, necesitamos mirarlos en conjunto y efectivamente todo lo que tiene que ver con autoconsumo puede ser una tremenda herramienta. O sea, también la transición energética es una oportunidad para reducir la pobreza energética de una manera distinta, ¿no? Entonces, la inversión en mejorar la calidad de las viviendas para poder tener más eficiencia energética y en la energía renovable, permite que muchos más hogares puedan acceder a mejor calidad de energía al mismo tiempo, ¿no? Pero eso es una inversión que tiene que tener esos dos elementos en el lente, porque el costo obviamente es más alto y es una perspectiva temporal mucho más amplia. Lo que no es fácil hacer cuando los tiempos políticos están pensando solo en la próxima elección, ¿no? Entonces ahí hay un problema estructural que tenemos que enfrentar. Pero por otra parte, también en países como los nuestros, donde la mitigación del cambio climático no tiene mucho sentido para gran parte de nuestra población, debido a que se visualiza que afectamos, o sea, aportamos muy poco a los gases de efecto invernadero, más bien somos víctimas, y no se entiende que tengamos que invertir tanto en eso si tenemos otros problemas urgentes. Pero si tú planteas invertir en transición energética y al mismo tiempo abordar problemas de bienestar, de pobreza, sí tiene mucho más sentido para nuestra población, ¿no? Entonces, obviamente hay que verlo en conjunto. Y en la nueva Constitución, efectivamente, en el borrador hay, nosotros hemos trabajado durante estos años en una red de pobreza energética que tiene bastante impacto a nivel nacional, y esta red logró poner un artículo en la Constitución, que es para acceder a energía, que el Estado tiene que asegurar el acceso a energía limpia, asequible, y además promover una red de infraestructura energética que sea diversificada y renovable. Apunta a ambas cosas. La verdad, nunca pensamos que realmente lo íbamos a lograr, y lo logramos. Lo único sí que ahora se tiene que aprobar, que no está nada fácil. Y por último, también hay un montón de otros elementos que ayudan en la nueva Constitución, que tienen que ver con la posibilidad de planificación del Estado, ¿no? O sea, el Estado se ve como un Estado que planifica, que proyecta, que promueve, que en realidad, por poco que sea que se haga, va a ser mucho más de lo que hay ahora, y eso va a permitir al menos tener una mirada de más largo plazo. Pero bueno, como digo, se tiene que aprobar primero, porque la verdad es que la campaña anticonstitución está del terror.
Thank you, Guillaume and Ron, for your questions. I think I can combine the answer together. I think people know China for the pollution problems typically, and also the top-down governance approach. But I think it's also an evolving governance system, and there are more and more what we call modern environmental governance approach in China that's changing the dynamic. For the first question I think it's on constitutional law. I'm not an expert on this, so I don't know the specific cases or terms in there, but I think there were changes in 2018 where there was the revision of the constitutional law, and also in 2020, which was the launch of the first civil codes in China, where they kind of incorporated this, what you mentioned, ecological civilization, but it's more at an ideology level, which is actually a very top-down implemented ideology in China these days. One concrete example on the ground is I show on the last slide, I showed it's a slogan where during my field work in China at a coal mine, or typically at every coal mine or coal plant you visit, you see a slogan that says clear water and green mountain is this silver and gold mountain, basically showing an example of what you mentioned as ecological civilization. So that's more at, I guess, at ideology level, but for legislation, I think it takes longer time to be more implemented. And in terms of how come they allow NGOs to even do this bottom-up approach of litigation, as I mentioned, again, it's an evolving system, so it actually takes a lot of years for NGOs to be incorporated in this process. Before 2015, there were struggles back and forth, they were limiting the number or eligibility of NGOs, making it actually very hard for them to be eligible. But then they opened such a door, but still closed certain windows in a sense that they still have a very restricted space. But on the other side, I think the government also say civil society as one important stakeholder that helps with monitoring, because the government realized the cost of recovery of these ecological issues in China, like coal mining, coal power plant. This is a huge amount of finance needed. And so NGOs with their expertise in monitoring and engaging local communities can to some extent support. And I think that helps in this process. Thank you.
Okay, so I think it's time to close. Yeah, you can say something, of course.
Sorry, thanks for the online presenters at Natalia. Can you hear me? Just want to make sure.
I do, yes.
Oh, okay, great. So you mentioned that a lot of what you classed as anti-regulation litigation is in relation to just transition. And I'm just curious if in those countries the litigation was posed under the constitutional environmental rights, or was it more of a procedural claim?
Yeah, so thank you for your question. That's a really interesting question. And what I can say so far is that, in fact, some of, as you mentioned, some of those cases have been presented alleging or, invoking the violation of fundamental rights that in some of the Latin American constitutions are embedded within the constitution. So to answer your question, yes, and as a result, some scholars have considered them as environmental cases rather than like just transition cases or climate litigation cases. But yeah, they mostly rely on human rights violations or fundamental rights violations within the rights embedded in the Constitution. Did I answer your question?
Yes, thank you.
Okay.
Thank you, Natalia. So thank you all to the panelists. I really enjoyed the being the moderator of this panel. I hope you also enjoyed it. So we will close this third panel. I think it's nice that we talk about Latin America, we talk about Europe, we talk about China. So we could speak about many places of the world. I think that's interesting. And yeah, if you, of course, I think you will have further questions. If you have, we can talk about it later. Now, Malka will close the Congress, well, the colloquium, the TIEC. And yeah, that's all. I encourage you to keep thinking about all these questions. And yeah, I think they needed an applause. And also thank you, Natalia, for being here. Yeah, so Malka, you can come now.
Good afternoon, everybody. I will try to keep it short because I know that it has been a pretty long afternoon, and yesterday you have all been here. I'm Malka. I am part of the organizing committee of the TIEC. I have been part of the TIEC since the first edition, I think in 2015, that we have been carrying this colloquium on. And I haven't been able to join you in person during these 2 days because of other obligations, but I have been following you online during these 2 days. And I would like to start by thanking all of you here today, online and here in this room, for assisting, for being part of this colloquium, and also, of course, Universitat Rovira i Virgili, our home, Agaur, the CEDAT, and all the different institutions that have always been part of the TIEC and continue collaborating and giving us their support in order to carry out this colloquium now for 7 years in a row. Not even the pandemic has been able to stop us. We have been able to keep carrying it on online, and this year on a hybrid modality, we could say. So we are really proud of it, that we have been able to keep doing it even though we have had many obstacles throughout the years. And I would also like to thank our keynote speakers, Andrews, Lea, and Anahí, for your participation, for your keynote speeches, which have really contributed a lot to enrich this colloquium. And also the scientific committee, because due to their work, we have been able to structure this program. We cannot forget them, Aitana, Francesca, and Roman. And of course, I would also like to thank all the people that have submitted abstracts, not only the ones that were selected, but also everybody submitting an abstract, because that is what also encourages us to continue organizing these kind of events, because we see that it is an interesting event, people are willing to participate, and that also motivates us to continue. And of course, the people that have been able to participate, and also with all your presentations as panelists, and also the people that have been able to join us, not only giving presentations, but as part of the public too, because the debate also enriches a lot the colloquium. It's not only the presentations that we're able to give, but also the questions that we received, and the debate is a great part of the TIEC. And now getting a little bit more into this year's topic, which was the legal challenges at the end of the fossil fuel era, shaping energy futures through legal intervention. What we really aimed with this topic this year was to reflect what were the challenges and how law can intervene into energy transition, in a just energy transition. And I believe that with all your presentations and all the interventions, we have been able to at least to try to point out some solutions, try to mark the way that we can follow in order to try to continue working in this sense. Regarding the first panel yesterday, what we basically did was to set a diagnosis of the current situation of what is going on in this, with what is the panorama, as we could say. Our keynote speaker yesterday, Andrews, pointed out a little bit what is the political economy situation, the political ecology situation surrounding the current energy crisis. And moreover, the panelists were also able to discuss different aspects such as the hydrogen, it's the role of hydrogen in perpetuating the fossil fuels, the use of fossil fuels, the legal challenges of regulating private investment, renewable projects, the misunderstanding of concepts that exist actually between environmental law and energy law. And also we have talked about investment agreements and the exploitation of the global south. On the second panel, Lea pointed out some important challenges, such as the role of the energy market, the need to restructure some patterns and the combinations between public and private property, and also the importance of readjusting competences between and the importance of national tribunals and the private and public sector. And also our panelists highlighted different aspects, such as the importance of clear legal frameworks, allowing for investment, the importance also of green hydrogen. And on the other hand, we also keeping in mind the energy transition, but keeping always in mind that for producing energy, we need energy, because we also have to be consistent of what the reality is. And then last but not least, today, Anahí contributed with us talking about the importance of government action, how we cannot separate concepts such as poverty and inequality when we are addressing the goal of reaching energy transition, and how can development and equity keep going hand by hand, and how it is complicated, but it must be taken into account. And we have addressed today also aspects like climate litigation, fair and sustainable transition, human rights, and extractivism. So a bunch of topics that are all related and linked, and that we have to keep in mind as not conclusions necessarily, but also ideas that we have to continue thinking about in order to address these challenges that we have in the legal world regarding energy transition. So we would also like to remind you, last but not least, I would like to thank my colleagues here from the TIEC, all the people from the organizing committee, Stephanie, Clara, Bea, Francisco, Paulina, Maru, Aloya, Lore, Gaston, Laura, and Monica, because without all their hard work, this wouldn't be possible. And also all the people that have contributed throughout the years, and probably this year have not been part of the organizing committee, but they continue giving some kind of support. And the teachers from the CEDAT, today here we have Andrews and Aitana, but all the professors from the CEDAT have been constantly giving us their support to organize this. And just to finish, just to remind you that we have the publication issue going on, so we will keep in touch with you. So if you're interested, you can also contact us and let us know. And two last aspects. The first one, we would kindly ask you if when we finish, can you please return the tags that we have given you, because in order to be ecological and sustainable, we reuse them for other events. And last but not least, which is also super important, after this, we were thinking about going to have a drink. So if you would like to join us, which is also part, the social part is also important part of the colloquiums, we will like for if you are, feel free to join us and we can all continue talking about the legal challenges or life or whatever you feel like talking about in general. And thank you very, very much for continue supporting us in the organization of this event. And we would, if we organize it next year, which we would hopefully do so, we hope that you can join us virtually or present here in person, but we will continue working with. Okay, thank you very much.